Good evening, ladies and gentlemen. Welcome again to the Cooper Union and to the Great Hall. I'm David Greenstein, Director of Public Programs, and I'm very happy to see you here for the last in the series of the John J. Islen Memorial Lectures for 2012. We've been extraordinarily lucky to have Professor Burt Neuborne of NYU Law School teaching us about the poetry of Madison's Constitution. And I'm very happy that once again in the audience are colleagues of his, former students of his, current students of his, members of the profession, and the rest of us who are interested in the subject of the American Constitution. So I'm very happy to welcome again Professor Burt Neuborne.
Thanks again for coming, and a special thank you to Lee Islen and to Cooper Union for inviting me to deliver these lectures. I am particularly grateful to so many of you whom I recognize and who have accompanied me on my excellent constitutional adventure. So thank you. I couldn't decide what to call tonight's lecture. My students know that I love movies, so I asked them which movie I should name the last lecture over, and I said I can't figure out whether it'll be Last Tango at Cooper Union, The Last Picture Show, or Le Dernier Metro, which are three of my favorite movies, and they voted unanimously to call it The Big Sleep. I finally settled on The Last Waltz, and so let's have it be The Last Waltz. We've spent the last 2 months reading the Bill of Rights as a great poem to human freedom, out of respect for James Madison's remarkable gift for organization, paying particular attention to the vertical and horizontal flow of the 31 ideas in the first 10 amendments. But the Bill of Rights is also part of an even larger project, the Founders' Constitution of 1787, that establishes and regulates the operation of American democracy. Now, the 1787 Constitution lists 3 branches of government in Articles 1, 2, and 3, the legislative branch, the executive branch, and the judicial branch, and allocates government power between and among them. Congress's job under Article 1 is to enact the laws. The President's job under Article 2 is to implement and enforce the laws, and the judiciary's job under Article 3 is to interpret and apply the laws to cases and controversies involving individual litigants. Now, the 1787 Constitution also lists the federal government's powers. Most importantly, Congress's power under Article 1, Section 8 to regulate interstate or foreign commerce and to declare war. It also limits the state's powers in Article 1, Section 10 whenever they collide with effective federal government, most importantly denying the states power to coin their own money, to levy tariffs on other states, to maintain an army or a navy, to carry out their own foreign policy, or to refuse to respect, and the founders called it giving full faith and credit to, the judgments of a sister state. Now, when you step back and look at the 1787 Constitution, you realize that it rests on 3 largely unwritten intellectual pillars: democracy, separation of powers, and federalism. As we saw in Lecture 2, the 1787 Constitution is suffused with the idea of democracy, but almost completely silent on how to go about achieving it. Lacking clear textual guidance, the Supreme Court initially stayed out of the democracy area altogether, largely leaving the care and feeding of the democratic process in the 19th and first half of the 20th centuries to local majorities, who often discriminated against racial, religious, or political minorities. When beginning in 1962, the Supreme Court finally intervened dramatically to protect democracy, it declined to embrace a theory of democracy, preferring instead to rely on the ambiguous text of the Equal Protection Clause and the First Amendment to shape American democracy. Now, as I argued in Lecture 2, that fateful choice has led us to our current accidental, often dysfunctional version of democracy, a judge-made version of democracy that no one would have chosen. But unlike the non-textual commitment to democracy, which the court declined to develop, the court has not hesitated to give judicial meaning to the other two non-textual pillars of the 1787 Constitution, separation of powers and federalism. Now, apart from the text itself, apportioning various powers and duties between and among the three branches, there is no constitutional text defining or codifying the principle of separation of powers, nor is there an explicit provision in the Constitution that prevents one branch of the federal government from seeking to usurp the constitutional functions of other branches. Madison sought to include such a provision in the Bill of Rights, but the first Congress rejected it. But the lack of such a textual hook, though, has not prevented the Supreme Court from evolving a rich and complex constitutional jurisprudence enforcing the unwritten principle of separation of powers, seeking to keep each branch from acquiring undue power by invading the turf set aside explicitly or implicitly for another branch. Now, as with democracy, in order to develop a coherent body of separation of powers law, the court needs a theory of what government powers are and why they should be separated. And that's particularly important in our constitutional system because Madison and the other founders broke with British practice and adopted a system that had never been tried before. British separation of powers theory divides government into two categories: Parliament's power to make new law and the King's power to enforce the law, lumping the judges in with the rest of the King's men. And that's why judicial review never developed in Britain. Madison chose the more elaborate model urged by Montesquieu, who viewed judges as exercising an ill-defined but separate and autonomous power. And Article 3 endorses Montesquieu by treating the judicial function as a separate power. And ironically, France, Montesquieu's native land, still can't bring itself to embrace Montesquieu. The Constitution of the Fifth Republic, the current Constitution of France, describes the judicial power as an autorité, something less than a pouvoir. It just can't get that last bit of saying that the judges are equal and independent. Now, in seventh grade civics, I was told that government, like Julius Caesar's ancient Gaul, is divided into three parts. One part, the legislature makes the laws. The other part, the executive, headed by the president in the federal executive, enforces the laws. And one part, the judiciary, interprets the laws and applies them in specific settings. Now, useful as such a general statement is, a moment's reflection reveals that it is hopelessly ambiguous. When Congress passes a law to carry out the commands of the Constitution, is it making new law or just enforcing existing law? When the president promulgates new tax regulations or securities regulations or environmental regulations pursuant to vague congressional statutes, is he making new executive law or is he just enforcing the old congressional statute? When the Supreme Court interprets vague statutes and ambiguous constitutional text, are the justices making new law or are they just enforcing old law? In short, the seventh grade civic separation of powers model is almost entirely dependent on the level of abstraction that we use to test the activity. Moreover, the seventh grade civics model doesn't tell us why we separate the powers, even if we could define them. At least two theories are possible. One I call negative separation, views government power like a bomb that can go off and hurt someone. So before the explosion, all three branches must concur in the exercise of the power, one branch by making the law, the other branch by enforcing the law, and the third branch by interpreting and applying the law. But no one branch can carry out more than any one of the three powers. So for the bomb to go off, three separate categories of officials must agree. It's a lot like cutting up the formula for a bomb into three pieces and giving each piece to a separate person, requiring all to agree before the bomb can go off. And that's actually what we do today with nuclear launch codes. So under negative separation, we don't have to define the powers too closely. We simply ask whether a single branch has the power to carry out more than one of the three functions. If so, we invalidate the outcome. Now, a second theory, that I call it positive separation, views governing as a very hard job and seeks to allocate the powers of government to the branch most likely to carry out the function efficiently and fairly. Under positive separation, the task of making the law is allocated to Congress as the branch that is representative of the many differing interests in our society, in the hopes that what comes out of Congress will respect and reflect the nation's diversity. On the other hand, the task of enforcing the law is vested in the President, a single person who can act quickly and forcefully without the need of harmonizing conflicting interests and views. And finally, the task of interpreting the laws and applying them to individuals in particular settings is allocated to the judiciary, specially trained to carry out the task and insulated from the other two political branches. Now, most of the time, negative and positive separation theories reinforce each other. Positively allocating government power functionally among the three branches also serves negatively to break the power up into three pieces. So there is a fundamental harmony between the two theories. And so when positive and negative separation of powers point in the same direction, as in the many cases where Congress not only makes a law, but tries to control how that law is going to be enforced, or when Congress enacts a rifle shot law that is designed to punish only one person, the separation of powers violation is easy to spot. Those are easy cases. But especially in the area of foreign policy, negative and positive separation theories may diverge. Negative separation argues against giving the President power to make law, interpret law, and apply law in the context of a foreign crisis, especially one involving the threat of war. And that's why Congress is given the sole power to declare war. But positive separation worries that burdening the decisional process in the midst of a crisis, foreign or domestic, with cumbersome negative separation of powers restrictions may adversely affect the government's ability to respond effectively to the crisis. Let me just recall the calls for unilateral president's response to the fiscal crisis in 2007 and 2008 when Congress seemed stalemated, and the seemingly irresistible growth of unilateral presidential power to commit our nation to armed conflict abroad without the concurrence of anybody else. Perhaps the greatest constitutional challenge of our age is to rein in an imperial presidency that threatens to swallow the other two branches, especially in the area of foreign threats to national security, and to do so without hamstringing our ability to react effectively. Separation of powers issues are most pronounced in the context of the judicial role. The treatment of captured foreign suspected terrorists poses a stark challenge to the separation of powers. One view, driven by traditional negative separation thinking, says that the terrorists are criminals and should be charged and prosecuted in an Article III court before an independent judge under the criminal procedure ground rules we discussed last week, with some leeway for tweaking the rules to reflect some of the difficulties of the prosecution. The opposite view is that the suspected terrorists are prisoners of war in a new kind of conflict, not governed by the Geneva Conventions, which gives the President, as Commander-in-Chief, unilateral power with no separation of powers to detain and punish them for violations of the law of war. I unsuccessfully argued almost a decade ago that neither alternative is palatable. I urged the creation of separate judicial tribunals staffed by Article III judges, civilian Article III judges, but operating under newly designed procedures calculated to assure both fairness and efficiency. I got nowhere. The ACLU called me a traitor, and the Pentagon tried to have me hunted down. And we're still trapped at the extremes. The Supreme Court's refusal in a recent case called Boumediene to permit the President or Congress to oust the Article III judiciary from its responsibility from supervising the conditions and hearings at Guantanamo and for assuring fair procedures in connection with the hearings was crucial to the very idea of separation of powers. If that case had gone the other way, separation of powers would have been thrown out the window in connection with the war on terror, and there's no telling what how quickly and how dangerously executive power would have grown. But I have to say, the resulting review process by the courts has been tepid at best and has no effect on the secret, unilaterally operated detention facilities that are maintained abroad. Nor has the judiciary established effective checks on the torture of suspected foreign terrorists or on unilateral presidential decisions to sentence persons to death by drone bombing. I believe it's more important to impose separation of powers in those areas than it is to get a necessarily correct definition of what the president can do. Because no matter how precisely you define what the president can do, if the president's men and women are the only people involved in the process and nobody else will ever know what they're doing, that definition is meaningless. It's only if other branches can peek over the shoulder of an imperial presidency and check the president can we ever hope to be able to have a serious check on an imperial presidency. And then finally, can the judiciary enforce Congress's exclusive power to declare a war against an imperial president who is bent on using forces without congressional authorization? Should it be able to do so? These are questions that are unanswered, but that are among the most important questions for democratic governance in the country today. I confess, I'm the lawyer many, many years ago who thought that courts should enjoin the Vietnam War. And I spent a lot of my young life running as hard as I could into stone walls, attempting to get courts to do that. But I believe that someday, sometime, the judges are going to have to take responsibility for the fact that Article 1, Section 8 gives Congress the power to declare war. And they did it for a reason, to make sure that you didn't have a unilateral president capable of committing the nation to sustained armed hostilities abroad in the absence of consent from the people. And that is a principle that it cries out for enforcement. In these settings, I believe, where positive and negative separation collide, and you can see how it collides. The positive separation, people say, gee, giving it to the president is great. Look at how quick the president can act, and look at how firmly he can act. The negative separation of people say, yes, but look at the power that he has, and no one person or one group of people should be able to have that power without some check. The collision between those two ideas is not answered in the text of the Constitution. It is not answered in our history. It is not answered in democratic political theory. It is answered in the values of the justices. And the justices themselves are making this up on the fly as we live from day to day. And you know what? There's no other way for them to do it. Now, federalism is the third non-textual pillar of the Constitution, along with democracy and separation of powers. Now, unlike separation of powers, federalism has a possible textual base in the 10th Amendment. Unfortunately, the 10th Amendment's text, which provides, let me read it to you in its entirety, the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. The trouble is that's just a truism. Of course that's true. The powers that are not given to the United States are left with the states, but it doesn't tell you which powers are given to the United States or how to decide when a particular power goes from one state, goes from the federal government to the states. So that the 10th Amendment is there. The trouble is it doesn't say anything, or at least it doesn't say anything obvious. I'm going to argue a little later that it says something important, but it doesn't say anything obvious. It's really just the flip side of the Supremacy Clause that tells us that properly exercised federal power is the supreme law of the land and ousts any state law to the contrary. But the Supremacy Clause doesn't tell us when power is properly exercised. They're both tautologies. They're both simply statements of truisms. Now, perhaps the 10th Amendment might mean that grants of power to the federal government should be read literally. That would be a possible way of giving meaning to it. But that approach is blocked by language in Article 1, Section 8, which gives Congress power to make all laws which shall be necessary and proper to carry out their enumerated powers. So the Constitution itself gives Congress the power to go beyond the enumerated powers to do things that are necessary and proper to carry them out. So that it makes it impossible to read the 10th Amendment as a literal amendment because the Constitution's text says it's not. It's not literal. So we're left with some, and people have been disagreeing about the complicated relationship between the 10th Amendment, the Supremacy Clause, and the Necessary and Proper Clause since a battle between Hamilton and Jefferson in Washington's first cabinet over the creation of the first bank of the United States. Jefferson said that the Constitution didn't give Congress power to charter a national bank because there's nothing in the Constitution about chartering national banks. Hamilton argued that it was granted by the Necessary and Proper Clause because it was important to help regulate commerce. Washington ruled for Hamilton and the bank was created. But today, the arguments are simply recycled by people both on the court and in the country, and we're no closer to a consensus than we were when Hamilton and Jefferson first raised the arguments back in George Washington's day. Now, what makes the judicial answer to the federalism issues particularly hard is that unlike separation of powers, where at least you could choose between two theories, there is no theory of federalism other than a decision to share sovereignty between the center and the periphery. How you share it is contingent on time and place. The genius of American federalism has been that it has operated flexibly, like an accordion, increasing and decreasing the relative powers of the state and federal governments in accordance with the necessities of a particular time. We've already seen one dramatic example of the shift of power from the state to federal government in the migration of the power to define individual rights through the magic of incorporating the Bill of Rights through the Due Process Clause. What was once a state power became a federal power through the incorporation of the Bill of Rights against the states. Now, for the past 85 years, events have conspired to encourage a steady flow of power from the states to the federal government. The stock market crash in 1927 and the ensuing Great Depression created a felt need for national market regulation, uniform national market regulation, both because local regulation would have been ineffective and perhaps more importantly, because leaving the regulation to the states during a depression would have triggered a race to the bottom, with the states competing for a shrinking pool of jobs by eliminating minimum wages, health and safety regulations, child labor rules, industrial zoning, environmental protection rules, employee health care, and maximum hour legislation. The Second World War only intensified the need for national power, with concern for national efficiency and order at its highest point as the nation fought for its life. The Cold War, Korea, and Vietnam extended the idea of a muscular federal national security state with the necessary resources and unitary power to act effectively to counteract the military, economic, and political threat from the Soviet Union. Now, with the defeat of Hitler, the enjoyment of the longest period of post-war sustained prosperity in our history, the passing of Stalin, and the eventual implosion of communism, much of the impetus for a unitary, strong national state decreased. And for a time, it appeared that power was once again flowing back to the states. Who needs a strong federal government in a time of prosperity, security, and peace? And the court's dramatic turn toward the states slowed and, I believe, stopped when the tragedy of 9/11 reignited the fear of a foreign foe, and when the financial collapse of 2007 reminded us of the necessity for effective nationwide regulation of the economy. Now, these days on federalism issue, the Supreme Court is divided between Republican justices who seek a return to the pre-New Deal narrow federal regulatory power and strong states' rights, and Democratic justices who believe in a strong federal government with pragmatically defined regulatory powers. The states' rights justices often invoke the 10th Amendment to protect their subjective definition of federalism. But their ideas rest on their own subjective political theories rather than any objective idea of a theory of federalism or something in the text. Just, for example, the challenge to President Obama's health care legislation. The 5 Republican members of the court ruled that Congress lacks power to require affirmative behavior as opposed to negatively prohibiting behavior under its Commerce Clause power, and that Congress also lacks the power to condition state eligibility for funds on the state acceptance of a separate regulatory program. The 5 Republican justices voted down the line on those 2 issues with conservative political theory that said no affirmative regulation and no blackmailing the states. The 4 Democratic justices dissented on each issue. Now, the Obama health care plan survived only because Chief Justice Roberts, in a modern version of what many call the switch in time that saved 9, which was the switch in 1937 to start upholding Roosevelt's programs instead of striking them down, one justice moved over, and that prevented the court packing plan from coming into effect. So it's always been called the switch in time that saved 9. I have a hunch that Chief Justice Roberts was thinking about the switch in time that saved 9 when he decided that the Obama health care was constitutional because the financial sanction imposed on persons who fail to purchase health insurance is really a constitutionally permissible tax within the meaning of Congress's power to levy taxes, and not a regulatory penalty under the Commerce Clause. So the states' rights folks won their 2 red meat federalism issues, but lost the case and probably the presidential election. That's how close President Obama came to losing his signature legislation and perhaps the presidency. Under current constitutional standards, therefore, the court grapples with hard separation of powers cases without a consensus on the 2 crucial questions of what are the government's powers, and 2, how should they be separated? And it also grapples with hard federalism issues without an underlying theory about how and why power should be divided between the state and federal government. It's fair to say in both areas there are no other areas more dependent upon the subjective value judgments of the justices than separation of powers decisions and federalism decisions, and where the divergence between the Democratic justices who tend to support national power and the Republican justices who tend to support states' rights, and the Democratic justices who tend to support negative separation and the Republican justices who tend to support positive separation, you see it over and over again. It is as entrenched in that area as it is in any other area of law. Now, I believe that properly read, though, as a logical closing point of Madison's great poem, the 9th and 10th Amendments can provide useful guidance on both separation of powers issues and federalism issues that will discipline, they will never eliminate, but will discipline the use of values. Now, the origins of the 9th and 10th Amendments are easy. It's reading the 2 clauses that's hard. During the debate over whether a Bill of Rights should be added to the 1787 Constitution, 2 powerful arguments against the Bill of Rights were mounted by opponents. Prominent anti-federalists, they were called, argued first that listing rights in a single document was dangerous because the draftsman would inevitably leave something important out of the laundry list of protected rights, giving rise to an inference that the founders didn't want to protect the omitted behavior, so that a listing of rights would freeze the rights at a particular time and there'd be no possibility of the growth of new rights. That was a very powerful argument against the Bill of Rights. In addition, the anti-federalists opposed the Bill of Rights because they argued that once you articulate a right, you imply that there was a government power to do something that requires the right. And so therefore, people will read backwards from the existence of a right to create powers that shouldn't exist in the federal government. Those are the 2 strongest arguments against a Bill of Rights. Now, Madison tried to deal with both arguments in a single provision. When he was drafting the original Bill of Rights, he tried to do it in a single provision, and he eventually broke them into 2 provisions. And those 2 provisions became the 9th and 10th Amendments. The 9th Amendment provides the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So it is a direct effort to say, don't worry. If we leave it out of the text, it doesn't mean that it doesn't exist. The 10th Amendment, as we've seen, says that if we don't give a power to the federal government, that means that the power is assigned to the states. So don't worry. You can't use the Bill of Rights to imply that there are powers that were not given to the federal government. So the two provisions have an obvious purpose. They were designed to answer the original opposition to the Bill of Rights. Now, I believe that Madison's placement of the 9th and 10th Amendments was intended, though, to do more than merely refute the objections to having a Bill of Rights. He intended to close his great poem to human freedom and to democratic order with instructions to future generations about how to read the text of both the Bill of Rights and the 1787 Constitution. Properly construed, the 9th and 10th Amendments, the Madisonian 9th and 10th Amendments, are more than truisms or vague instructions about federalism and natural law. They are keys to deciphering the entire constitutional text. Unfortunately, current readings of both amendments are mired at the extremes in a classic confrontation between Republican and Democratic interpretations of the text. Some Democrats read the 9th Amendment as an invitation to the judiciary to create new, non-textual rights enforceable against the political majority and guided only by the justice's sense of what human dignity requires. In short, those Democrats view the 9th Amendment as codifying and creating a window to natural law, a Kantian idea of the rights retained by human beings in the natural order of things because of their dignity as a human being. The idea of natural law, at least since Kant, has been a magnificent banner behind which millions have struggled for human decency in a world governed by authoritarian tyrants ranging from left to right across the political spectrum. It was the banner that the United States carried in its life or death struggles with Nazism and communism. It is the banner that we hold out today to the Arab Spring, to Chinese dissidents, and to the emerging democracies of Asia, Africa, and South America. But because it is hopelessly subjective, natural law is not a useful governing concept in a tolerably fair democracy that already recognizes human dignity. For example, a reasonably developed theory of natural law can protect a woman's right to choose, but it can also protect a fetus's right to life. In short, the idea is a beautiful vessel into which we pour our most cherished personal values. And in a free society, we have no right to force others to embrace and to live by our personal values simply because we label them as natural law. That's what tyrants often do. And a moment's reflection reveals that the 9th Amendment, the democratic reading of the 9th Amendment, natural law theory, is just substantive due process in liberal drag. It is simply the same thing that was done in connection with the substantive due process clause. So for me, the current democratic reading of the 9th Amendment fails, but the Republican reading is even worse. When Robert Bork, during his confirmation hearings, was asked about the 9th Amendment, he dismissed it as an ink blot. According to the Republican reading, the 9th Amendment is simply a truism with no practical effect. In fact, the Republican reading comes very close to enacting the anti-federalists' fear that the presence of textually described rights in the Constitution negates the recognition of non-textual rights unless the Constitution is formally amended. So for me, the Republican reading of the 9th Amendment fails as well. The 10th Amendment is equally stuck at the extremes, only this time the political positions are reversed. The Republican reading of the 10th Amendment views it as an open-ended invitation to the justices to entrench their subjective vision of American federalism into constitutional law. The Republican reading encourages the justices to identify what they consider to be the inherent attributes of sovereignty. Sounds like natural law, doesn't it? And to protect them against federal usurpation. The problem is that there is no consensus listing of what counts as an inherent attribute of sovereignty, leaving the 10th Amendment hostage to the non-textual political theories embraced by a majority of the justices. And the Democratic reading of the 10th Amendment is equally untenable. Democrats, echoing Robert Bork's inkblot approach to the Ninth Amendment, argue that the 10th Amendment is simply a truism, too amorphous to be given firm judicial content. Now, some justices, anxious to adopt a politically neutral view of both the Ninth and 10th Amendments, embrace the view that neither the Ninth nor the 10th Amendment is judicially enforceable. But that view simply erases fully 20% of the Bill of Rights and gives up much too easily on Madison's poetry. If I'm right, that not a word in the first 8 amendments is out of place or just there for window dressing, why would Madison have ended his great poem by reciting 2 Hallmark card nostrums just to satisfy a few anti-federalist critics? In fact, Madison ends his great poem, overflowing with ambiguous language in the first 8 stanzas, with brilliant directions to future generations about how the ambiguous text of both the Bill of Rights and the 1787 Constitution should be read. And Madison, being Madison, didn't just insert generalized canons of construction. He included an operations manual known to the lawyers of his day and known to us, familiar to us today. He starts with 2 general canons of construction. The Ninth Amendment tells us that when rights are at stake, we should adopt a broad reading of the constitutional text. In short, when genuine doubt about textual meaning exists, break the tie in favor of freedom. The 10th tells us to do exactly the opposite when government powers are at stake. When the constitutional text is ambiguous, Madison instructs us to read the text narrowly. In short, when the text is genuinely ambiguous, choose the reading that limits government. The interaction between Madison's reciprocal injunctions to construe the rights-bearing provisions broadly and the power-granting provisions narrowly, if understood properly, is the single most important structural attribute of the American Constitution. It, not ambiguous parchment barriers, is the key to keeping us free in the perilous present and the unknown future. But Madison didn't stop there. Polonius-like nostrums about reading ambiguous constitutional text, valuable as they may be in many settings, were not his style. He was one of the greatest common lawyers of his day. So Madison embedded his instructions about how to read the text in British parliamentary tradition that gives precise meanings to his canons of construction and tells us 221 years later how to apply them in specific settings. British lawyers in Madison's day were familiar with 2 competing ways of reading ambiguous statutes that had developed over hundreds of years of British parliamentary tradition. One, hermeneutic technique, and a hermeneutic technique is just a fancy word for how you read text. One hermeneutic technique, summarized by the Latin phrase inclusio unis et exclusio alterius, reads British statute very narrowly. What it says is, if you include something in the statute, you must be intending to exclude anything that you left out of the statute. So if you adopt that canon of construction, you look at the statute, if it's not in the statute, then it means that they didn't want to put it in the statute, and therefore you read the statute narrowly. While the competing tradition, the competing hermeneutic technique, was known as applying what they called in those days, and still today, the equity of the statute, which authorized British judges to read British statutes broadly. The equity of the statute authorized a British judge to expand a statute to closely related settings by analogy when such expanded coverage was necessary to make the textual provisions effective. As it was with its great rival, equity of the statute is politically neutral. It can be used to expand the legislative acts of tyranny or to fill holes in needed reform statutes in order to make them more effectively, work more effectively. I believe that Madison, fully cognizant of the debate between inclusio unis and equity of the statute, which was the red meat of everything that was going on in British parliamentary arguments at that time, licensed American judges in the Ninth Amendment to apply the disciplined technique of equity of the statute to the construction of the rights-bearing provisions of the constitutional text. And that is the remarkable gift he gives us in the Ninth Amendment. Under Madison's Ninth Amendment, the recognition of a new Ninth Amendment constitutional right, a non-textual constitutional right, is not simply an open-ended exercise in natural law. It's legitimate only if we can link it to an existing provision of the constitutional text, demonstrate that the new right is both closely analogous and harmonious with the constitutional text, and that it is needed to make the text work more effectively. Thus, when Justice Harlan added a seventh non-textual right, freedom of association, to the six textual ideas in the First Amendment, establishment, free exercise, speech, press, assembly, and petition, he was engaging in a classic exercise in the application of equity of the statute. The new First Amendment right, freedom of association, was closely analogous to the textual rights to which it was joined, verbally harmonious with the existing text, and most importantly, desperately needed to make the existing text work. Justice Harlan invented freedom of association to shield the NAACP from hostile legislative investigations designed to reveal its Southern membership lists. If, as I argued, the six textual ideas in the First Amendment are organized to reflect the evolution of a democratic idea into law, freedom of association was desperately needed to protect that process from destruction at the hands of a hostile state. And today, that same equity of the statute reasoning is available to justices under the Ninth Amendment to identify the non-textual protection of the right to vote and the right to run for office that hovers unseen at the close of the First Amendment's text. In connection with this presidential election, voter suppression laws in at least 19 states were fought to a standstill, with not a single one in effect on Election Day. But the doctrinal twists and turns needed to achieve that result were absolutely mind-boggling. Believe it or not, the democratic disaster known as Bush v. Gore was invoked to strike down the Ohio voter suppression law. It would be so much easier to listen to Madison's music and to recognize the right to vote waiting in the shadow of the equity of the statute at the close of the First Amendment. That's where the court's power in Roe v. Wade came from, to recognize the equality-based need of women to protect their rights to control their reproductive freedom. The equality and due process clauses lend themselves to equity of the statute's expansion in closely analogous settings needed to make them effective. That's where the protection of gay marriage is to be found. You can't be fully equal if you can't form lasting bonds with one another. Equity of the statute permits us to recognize freedom of intimate association that protects the family as one of the fundamental building blocks of American society. Now, Madison's disciplined Ninth Amendment instruction about reading the rights-bearing provisions of the constitutional text against the equity of the statute, and this is a legal concept that lawyers in Madison's time knew exactly how to use. His adoption of equity of the statute in the Ninth Amendment is paralleled by his treatment of the Tenth Amendment. Only in the Tenth Amendment, instead of equity of the statute, Madison deploys the counter, equally disciplined technique of inclusio unis as the core of the Tenth Amendment. The application of the Tenth Amendment inclusio unis to congressional power is complicated by the necessary and proper clause that stretches the literal reach of enumerated powers. But something is necessary and proper if you're going to be faithful to the idea of inclusio unis only if it is linked to a textual grant of an enumerated power and it is demonstrated as necessary to render that enumerated power effective. And that's why Chief Justice Roberts' healthcare opinion is wrong. Roberts held that Congress lacks the power under the Commerce Clause to require individuals either to purchase health insurance or to pay a modest fine. He conceded that Congress possessed power to regulate the healthcare insurance market under the Commerce Clause by imposing negative prohibitions, but lacked power to mandate the affirmative purchase of health insurance. Now, it's true that mandating affirmative behavior is often deemed by thoughtful libertarians like Isaiah Berlin to be a greater interference with autonomy than negative prohibitions. But we have long since crossed that barrier. We compel military service, jury service, education, filing tax return, vaccinations, motorcycle helmets. Rules mandating the purchase of health insurance is just another small step. Now, given the difference, though, between affirmative and negative regulation, the 10th Amendment instructs us to be cautious about expanding the power to regulate interstate commerce, with each form of implementation subject to review for necessity. Thus, the power exists only if it is shown to be genuinely necessary to regulate the healthcare market. The court's Republican majority treated the move from negative to positive regulation as an absolute libertarian Rubicon that could not be crossed without changing the nature of the federal union, at least the nature of the federal union as they subjectively conceive it. The court's Democratic majority acknowledged the difference between negative and positive regulation, but insisted that Congress could take the additional step of regulating a broad swath of persons affirmatively, because in the almost unique setting of the healthcare market, the affirmative power was necessary to make the Commerce Clause regulation effective. The refusal on the part of the Republican majority to recognize that even necessary regulation can fall within the necessary and proper clause is a perfect example of how the ideological insistence upon reading the 10th Amendment as a federalism idea instead of as an idea, a pragmatic idea that allows government to function most effectively is one of the great serious problems of federalism jurisprudence that we have to deal with. I'll give you just two examples. Two cases dealing with state-imposed, two cases. One dealing with term limits on how long a congressman can serve, and two dealing with whether Congress has the power to ban guns near schools. Those are two very important federalism cases. And they illustrate the application of the Ninth Amendment equity of the statute and the 10th Amendment inclusio unis. The term limits cases, dealing with efforts by states to impose term limits on their members of Congress, were not easy. Article 1, Sections 2 and 3 set 3 qualifications for serving in Congress: age, citizenship, and residence. The issue is whether the 3 qualifications were designed to establish a minimum floor or to establish a maximum ceiling. Could a state add a 4th qualification on its own members of Congress? History, text, and doctrine ended in a flat, literal 4-4 tie. Since, however, the concept of mandatory term limits would deprive many voters of the freedom to vote for certain preferred candidates, it clearly falls under Madison's Ninth Amendment injunction that when you're not sure, you read the text in favor of freedom. And Justice Kennedy correctly cast the 5th vote to invalidate term limits. Similarly, the issue of whether Congress has power under the Commerce Clause to ban guns near a public school was far from easy. The ban had little or nothing to do with directly regulating the economy, and it was defended as needed to safeguard quality education, which is crucial to a commercial success. Whether the necessary and proper clause could support such an extended causal chain is not an easy issue, especially when Congress never explicitly invoked it when it passed the statute. And once again, the arguments ended in a 4-4 tie. Now, since, however, the existence of government power was at stake, the case falls under Madison's 10th Amendment inclusio unis injunction, where ties are broken against government power. And Justice Kennedy, once again, cast the 5th vote to invalidate Congress's effort to expand regulatory power. Understanding the 9th and 10th Amendment as characteristically wise instructions from Madison about how to read his great poem to freedom allows us to see the Bill of Rights in its complete majesty. You recall that in Lecture 1 I argued that it was impossible to read the Bill of Rights as an objectively knowable set of commands. I argued that judicial values must and should play a role in construing the luminous abstractions of the Bill of Rights. The 9th and 10th Amendments provide a disciplined framework for making the inevitable judicial value choices. In Lecture 2, I argued that despite the lack of textual provisions protecting the right to vote, there was an obligation on the part of the Supreme Court to step in and help us build a robust, fair, egalitarian democracy. The Ninth Amendment's disciplined endorsement of equity of the statute licenses, indeed it commands, the modern justices to use analogy and broad construction to expand the text to preserve robust and egalitarian democracy. In Lecture 3, I sought to recover the poetry of Madison's First Amendment with its carefully organized horizontal protection of the interior precincts of the human conscience through 3 concentric circles of political engagement, articulation of the idea as part of the speech clause, mass dissemination of the idea under the press clause, and political organization in support of the idea under the assembly clause, culminating in formal interaction with the state under the petition clause. Properly read, the First Amendment is an instruction manual for the robust egalitarian democracy that the Ninth Amendment commands the Supreme Court to protect. In Lecture 4, I concentrated on the first 2 ideas in the First Amendment, a ban on establishing religion and a guarantee of the free exercise of religion. I argued that Madison viewed religion with respect as a form of divine madness, capable of moving believers to magnificent heights of human decency and courage, but also capable of driving believers to commit horrible acts of violence and intimidation. The Ninth and Tenth Amendments permits the justices to develop a doctrine that advances and protects both of Madison's concern. In Lecture 5, I moved to Madison's Second Amendment, arguing that both Republican and Democratic readings of the Second Amendment overlooked Madison's music by failing to understand that the right to keep and bear arms does not mean the unregulated ability to possess and carry loaded guns in public, as a federal appeals court has just held, but the right to serve equally in the military and police forces, the nation's modern organs of armed coercion. The Ninth Amendment adoption of equity of the statute virtually compels such a reading. In Lecture 6, I sought to capture the painful evolution of the principle of equality in our constitutional heritage, beginning with a document protective of slavery and slowly evolving into a document deeply protective of formal equality. I pointed out, though, that the real challenge now is to move from formal to substantive equality. The Ninth Amendment is the bridge from formal to subsequent equality. In Lecture 7, I described the 3 roles the Due Process Clause plays in our constitutional system, ranging from applying the Bill of Rights to the states, insisting upon procedural fairness, and the enforcement of non-textual rights. Now, viewed through the lens of the Ninth Amendment, equity of the statute, both the migration of the rights from the states to the federal government through the incorporation theory and substantive due process is less troubling. Incorporation of the Bill of Rights against the state is a classic example of equity of the statute. Reading the 4 operative words of the Due Process Clause broadly to add an analogous non-textual rights needed to make the textual rights effective. And substantive due process may be seen as an application of equity of the statute. Indeed, it can be defended more effectively if it is treated as equity of the statute. And last week, we turned to a remarkable organizational structure of the Fourth through Eighth Amendments. The Ninth Amendment equity of the statute licenses, it compels the conscientious judges to link the texts of the Fourth through Eighth Amendment together in a seamless web of constitutional protection. And finally, this week, we look briefly at separation of powers and federalism as the second and third non-textual pillars of the Bill of Rights. Now, separation of powers has many theories, but no explicit textual support. Federalism has ambiguous textual support, but no theories. Madison's Ninth and Tenth Amendments, read as metacanons of constitutional construction, supply both the text and the theory in both settings. Madison's Ninth and Tenth Amendments close his great poem, To Ordered Liberty, with a priceless gift to the future, instructions on how to read it to keep us free. May we be worthy of James Madison's gift and find the courage to recover his magnificent lost music. Thank you. Thank you. I'm retiring now. It doesn't get any better than that. Really, thanks so much. Questions? As we've done in each of the lectures, I'm happy to take a question. Come to the mic so everybody else can hear, and I'll try to blunder through an answer.
Sure. Hi, Professor. I've got a question, and it's in part a criticism. This is the only lecture I've attended, and it comes to your reading of, I guess it's contrasting your reading of the 9th and 10th Amendments, and then your criticism of the Affordable Care Act case, and also the recent, I think it's Morse v. Madigan, the Second Amendment decision that came out of Chicago. So if I have you correct, you say that when we look at the 10th Amendment, it is a canon of construction that judges must use. And here it is, if there's an ambiguity in the power of the federal government, this is a 10th Amendment, that power must be construed narrowly.
Unless it falls under the necessary and proper clause.
Unless it's under the necessary and proper. But you then criticize the Obamacare decision of Chief Justice Roberts as not recognizing that the individual mandate falls under the Commerce Clause. On the one hand, you recognize, you sort of accept his reading that there's a bright line between the individual mandate, which actually compels people to act, in every earlier instance in which the Commerce Clause was used. So I just have trouble...
but I see where you're going, but you're...
Well, I have trouble understanding, since if you're saying it needs to be narrowly defined...
But you're running headlong, you're ignoring the necessary and proper clause. My disagreement with Roberts is not that he recognized that affirmative power is more dangerous than negative power. I happen to agree with him. I think it is. And not that since this is a jump, the 10th Amendment should apply, but he read the 10th Amendment as creating a kind of absolute federalism theory that forbade positive regulation no matter what. And all I'm saying is that in order to invoke the positive regulation, the president had to prove that it was necessary. And he did prove that it was necessary. You can't regulate the healthcare market any other way.
Well, true, but it's necessary and proper. And I think Roberts said, it's not proper under the,
Okay. Well,
and so there's that, and there's also just the recent...
Well, if he's saying it's not proper because it violates my subjective vision of federalism, if that's what he says, I know it's necessary, but it's not proper because it violates my subjective vision of federalism, that is exactly what's wrong with using the 10th Amendment to create iron-bound ideological norms that come only out of Chief Justice Roberts' heart. Now, he believes in them, but how do you know it's not proper to use affirmative regulation when it's necessary to regulate the health market? How do you know that that's not in the Commerce Clause?
Well, for the same reason you just gave, which is if you have an ambiguous power, it needs to be construed narrowly.
Well, you're making an argument that renders Madison's position totally simplistic and ignores the necessary and proper clause.
No, all that I'm doing is
enough.
I'm sure...
That's enough. Let's take something else.
Well, I'm just
That's
pointing
enough.
out your analysis. If you don't like the policy outcome...
You win.
No.
Next.
You're not interested.
I think there are two issues that are getting confused. I think that there's the structure of the Constitution. And the second issue is whether any particular action is prudent. Prudent is a good idea. And just what you were talking about with respect to the interpretation of proper. What you were saying was that this was Robert's idea of what was a good idea or not. It's a prudence concept. It's not a structural concept. And I think what has happened is that because of a frustration of being unable to effectuate one person's view of prudence, there's been a whole line of theory gathered up to attack structure. And that's a really terrible thing
that's a great way to put it.
That has gone on. And that we are taught in the common law how to solve that problem. The common law dealt with law and equity. And equity was invented to balance law. And equity is You can use the Chancellor's foot or your definition of proper sometimes, and sometimes not. And in this debate on federalism and the interpretation of constitutional laws, we're losing sight of the role of the common law and how it teaches us to do things. On one side of the balance is stare decisis, don't change things too quickly. And on the other side is the judge, on the basis of equity, makes a new decision because it's time to change. All of the accretion of power in the United States, both on state and federal government level, has been an incremental, pragmatic accretion. It didn't spring out of the head of Zeus. It was in response to something that happened. Mm-hmm. So what we have now is a really misguided, skewed attack against structure that really is an attack against how we're actually doing things, carrying them out, prudence, what is proper, things like that.
No, it's very thoughtful. It is. It's very thoughtful. There's a big difference between, of course, doing this under the common law and doing it as a matter of constitutional law. Common law, if courts do something and put their prudence into the law, the legislature can overrule it. When a judge takes his idea or her idea of what's prudent and turns it into unyielding constitutional doctrine, it can't be changed by anybody. And so you've got to be much more careful about using prudence and dressing it up as constitutional law in a constitutional setting than you have to do in a common law setting. But with that qualification, I completely agree with what you said.
So I understand from my 7th grade civics class why we have the separation of power. What I don't understand as much is the federalism clauses and the amendments related to that.
You don't understand, I'm sorry, federalism, is that?
I mean, I understand what
I just didn't hear it.
Yes, and I understand what it means, but I don't understand why we're so attached to it, because I feel like in the beginning it made sense. You didn't want to have this reign of a king, or you didn't want to have the federal government overtake all the rights of the states. But at this point, it seems a little superfluous.
No, there are very good reasons to be very deeply attached to federalism. The officials are linked to the people, and the more intimately they know what the people needs. And then the third one, and this is the one that persuades me, is known as the laboratory of democracy, of federalism. Having federalism, having 50 states with genuine power to experiment with different ways to solve social problems means that we can work out different things and see whether it works in Wisconsin or whether it works in Florida. And that's a hugely valuable thing to do, because the truth is nobody knows the right answer to a lot of these questions. We're better off working them out in a laboratory of democracy, than a federal laboratory, than betting all the chips on one federal answer to it. So those are the three reasons.
I definitely hear what you're saying, and I think with a lot of things it makes sense. And healthcare to me seems like the last sort of right that's really in this conflict that maybe should be allocated federally, but we have allocated to the states. And there's this conflict over where it should be allocated. And I worked in healthcare and read about different countries' healthcare plans and was very invested in sort of getting across working in politics eventually on this sort of universal healthcare legislation. Now that's sort of happened to some extent, but it's still caught up in this, does Chris Christie want his own health care plan? Does he want to put something across? Does he want the government's health care plan? Which one's better? And this idea that we didn't, Obama took so much away because there was so much fighting about states' rights. He took the ability of the government to create something that would sort of compete with the insurance companies. He took that away so that the law could pass. And it's, I guess, with many other things, we've allowed the power to go to the federal government, and it seems like this is sort of, we're holding on tooth and nail, and I don't really get what we're holding on to for that. The states haven't benefited. There's loads of money wasted. There's a lot of different things that have gone wrong rather than right. And, I guess with that, I don't know what the benefit is of the separation.
Okay, well, I'm not sure I could answer your question. Next. I wish I could.
Hi. This should be a simpler question, I'm hoping. I'm wondering if you could recommend a book that would talk about the process of trying to pass the Bill of Rights back in 1789.
Oh, sure. You know what I'll do? There are any number. There's some wonderful books. I'll put it on the Cooper Union website.
On the which website?
On the Cooper Union website.
Okay,
so
good.
if you'd like that, I'll put a couple of books on. There are several wonderful books about the story of the argument about the Bill of Rights. Those of you, by the way, who haven't seen it yet, you got to go to see Lincoln, which is the great picture,
yeah.
great movie about the 13th Amendment, how it came into being. But there are several excellent books, and I'll put them on the.
I'm thinking basically of Pauline Myers' ratification of the Constitution. I don't know if you've read that.
Well, that's
it's
a fine
similar.
book.
Yeah,
That's a
what I'm
fine book.
looking
But there are 3 or 4 that are really very readable
Thank
and very
you very
useful.
much. And you've
happy
been
to do it.
terrific. You've been terrific.
Thank you.
Really.
Thank you, guys.
Thank you.
Now that I don't have to do this every Thursday night, I'm coming to visit many of you at about midnight. When you snuggle down to bed, I'll be there to talk to you as you want to drift off. Okay?